Hello and welcome to another lecture of the Law of the Sea. So today we're going to talk about some key terms of the Law of the Sea. I am Muhammad Tahmidul Islam, lecturer in Department of Law, World University of Bangladesh. Law of the Sea is a body of customs, treaties and international agreements by which states maintain order, productivity and peaceful relations on the sea. So here we can see that Law of the Sea's definition has been provided, which says that it is a body of law. The main function of the body is to maintain order, to maintain the productivity and peaceful relations on the sea. So there are many terms. The first term is the coast. Coast is the land beside or near to the sea. And then baseline, it is the line that borders the sea and the land or continent. Then comes the coastal state. Coastal state is a state which possesses the sea. It is from which the sea begins. Internal waters. It means waters on the landward side of the baseline of the territorial sea. Summarily, all waters are within the territory of a coastal state, save for the sea. Seabed. Seabed is the floor of the sea. It is the ground under the sea. Airspace is the part of the sky where planes fly. Usually it is under the legal control of a state below it. Subsoil is the layer of soil between the surface of the ground and the hard rock underneath it, the soil lying immediately under the surface soil. And now let's talk about the governing laws. There are 5 major conventions directly governing international law of the sea, namely Convention on the High Seas 1958, Convention on the Territorial Sea and Contiguous Zone 1958, Convention on the Continental Shelf 1958, and Convention on Fishing and Conservation of Living Resources of the High Seas, which is also promulgated in 1958. And the last one, and the most important one in my opinion, is the United Nations Convention on the Law of the Sea, or UNCLOS 1982. So here we can see that the first 4 conventions have actually been promulgated in the same year, 1958. So 1958 was a very important year for the international law of the sea, and the last one, which has been promulgated in 1982, the United Nations Convention on the Law of the Sea, which actually covers a lot of the area regarding the international law of the sea. So now let's look at a picture. In this picture, we can see that different zones of the sea have been provided. So the sea is divided into different zones. The first one is the outer space, which is the space in which no country has exclusive territorial control. Outer space is for everybody. And then we have the national space below it. And the national airspace, the state has full control over the national airspace, and which goes to 12 nautical mile from the baseline. And the baseline is where the land and the water meets, or the shore. Where the water hits the land is what we call the baseline. So 12 nautical mile from the baseline is the area of national airspace, and also the seabed is called the territorial sea. And then if we go beyond that, if we count 24 nautical miles from the baseline, we see that the rest of the part beyond the territorial sea is called contiguous zone, which goes to 24 nautical miles. And from the 12 nautical miles, if we look up, it is the international airspace, which is the domain of every country. And beyond the contiguous zone, we can see that there is high seas, and the exclusive economic zone is actually 200 nautical miles from baseline, and the continental shelf starts from the 12 nautical mile line, which goes directly to the deep sea bed, which is actually important for natural resources. Now let's talk about the territorial sea. It is a zone in the sea which ranges up to 12 nautical miles, or 22 kilometers from the baseline. It is also known as the Maritime Belt or Territorial Waters. So territorial sea has two different names. It can be called as Maritime Belt, or it can be called as Territorial Waters. It is under the sovereign jurisdiction of the coastal state actually. So the coastal state has full jurisdiction over the territorial sea. The coastal state has a right to make laws and regulations on the use of territorial sea. It has to allow innocent passage as required by the 1982 Convention, whereby innocent passage means is a passage that is not prejudicial to the peace, good order, or security of the coastal state, which has been said in Article 19 of the 1982 UNCLOS Convention or UN Convention. Innocent passage has to be consistent with the 1982 Convention as well as other rules of international law. Now let's talk about warships. And warships are important because in the law of the sea, warships hold a special position. They are ships belonging to the armed forces of a state bearing the external marks distinguishing such ships of its nationality under the command of an officer duly commissioned by the government of the state and whose name appears in the appropriate service list or its equivalent and manned by a crew which is under regular armed forces discipline. Warships enter the territorial sea has to abide by the regulations set by the coastal state. If they default, a coastal state has a right to restrict its landing. So warship has the power or has the authority to enter into the territorial sea, but upon entering the territorial sea, they have to follow the rules and regulation of the coastal state. If they do not follow, the coastal state has the power to restrict their actual entry into the place. So now let's talk about the criminal jurisdiction of a coastal state. The criminal jurisdiction of the coastal state should not be exercised on board a foreign ship passing through the territorial sea to arrest any person or to conduct any investigation in connection with any crime committed on board the ship during its passage. Article 27 of the 1982 Convention. So it has also been said in Article 27 that the criminal jurisdiction of the coastal state, it should not be exercised on board a foreign ship. Even the foreign ship is inside the territorial sea. The coastal state may exercise its criminal jurisdiction over a foreign ship if there are these circumstances. So under these specific circumstances, the coastal state may have the power to exercise the criminal jurisdiction of that state. Number one, if the consequences of the crime extend to the coastal state, so if the consequence of the crime actually falls in the coastal state, they can use criminal jurisdiction. Number two, if the crime is of a kind to disturb the peace of the country or the good order of the territorial sea, also it is affecting the territorial sea or the territorial country. If the assistance of the local authorities has been requested by the master of the ship or by a diplomatic agent or consular officer of the flag state, and if such measures are necessary for the suppression of illicit traffic in narcotic drugs or psychotropic substances as provided in Article 27. And civil jurisdiction, the coastal state should not stop or divert a foreign ship passing through the territorial sea for the purpose of exercising civil jurisdiction in relation to a person on board the ship. The coastal state may not levy execution against or arrest the ship for the purpose of any civil proceedings, save only in respect of obligations or liabilities assumed or incurred by the ship itself in the course or for the purpose of its voyage through the waters of the coastal state. It has a right to all resources living and non-living within it. Now let's talk about the contiguous zone. It is a zone not exceeding 24 nautical miles or 44 kilometers from the baseline from which the breadth of the territorial sea is measured. Article 33 of the UNCLOS. It is the zone after the territorial sea. The territorial sea goes to 12 nautical miles. So, contiguous zone starts after 12 nautical miles. The coastal state may exercise the control necessary to prevent infringement of its customs, fiscal, immigration, or sanitary laws and regulations within its territory or territorial sea. It may also punish infringement of the above laws and regulations committed within its territory or Territorial Sea. Exclusive Economic Zone, or EEZ. EEZ is an area beyond and adjacent to the Territorial Sea. It is a zone not exceeding 200 nautical miles or 370.4 kilometers from the baseline from which the breadth of the Territorial Sea is measured. The coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superadjacent to the seabed and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents and winds, the establishment and use of artificial islands, installations and structures, marine scientific research, the protection and preservation of the marine environment, Article 56 of the 1982 Convention. Rights of other states in the EEZ. All states, whether coastal or landlocked, enjoy, subject to the relevant provisions of the Convention, 1982 Convention, of navigation and overflight and of the laying of submarine cables and pipelines and other internationally lawful use of the sea related to these freedoms, such as those associated with the operation of ships, aircraft, and submarine cables and pipelines. Article 58. So in this point, we can see that the other states also have certain rights which goes into the EEZ. So what are those rights? These rights are the lawful use of the sea, which is related to the freedom associated with the operation of ships. So they can operate any kind of ship within the EEZ and they do not have to take permission from the coastal state. They can also fly aircraft and also they can operate submarines in the EEZ and not alert the coastal state. They can also put submarine cables and pipelines inside EEZ and they should not have to take permission from coastal states. Now let's talk about the continental shelf. Continental shelf. It is the geological term to mean the area of land on the edge of a continent that slopes into the sea. So continental shelf is actually the edge of the continent or edge of the land mass. It comprises of the seabed and subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory to the outer edge of the continental margin, or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin does not extend up to that distance. Article 77. The coastal state exercises over the continental shelf sovereign rights for the purpose of exploring it and exploiting its natural resources. So the continental shelf, in that region, the coastal state has the primary power. The delimitation of the continental shelf between states with opposite or adjacent coasts shall be effective by agreement on the basis of international law, as referred to in Article 38 of the ICJ statute, in order to achieve an equitable solution. So continental shelf and the delimitation of it is actually up to the individual countries, and they have the power to create agreement between them, among them, to delimit the usage of the continental shelf. If no agreement can be reached within a reasonable period of time, the state concerned shall resort to the procedure provided in Part 15 of the 1982 Convention. So if there is no agreement, Part 15 has a solution for that as well. The high sea. The high sea is a zone above 200 nautical mile above the EEZ. Unlike other zones, it is not under the jurisdiction of the coastal state or any other state. All of the freedoms available to the coastal state on the 200 nautical mile, that freedom on the high seas is for all states. Affairs in the high seas are regulated by the International High Seas Authority. Seabed. It is the floor of the sea and it includes the ground under the sea. The deep seabed is a part of the seabed that is beyond national jurisdiction and is referred to as the area in the UN Convention on the Law of the Sea. Airspace Jurisdiction. The airspace under jurisdiction of the coastal state is that of the 12 nautical or territorial sea or maritime belt. It is called national airspace. So the part of air which is beyond, which is actually over the territorial sea or 12 nautical mile is called national airspace, as we have seen in the picture uh, that came before. Airspace above the 12 nautical mile is called international airspace. International airspace does not include outer space, which under the Outer Space Treaty of 1967 is declared to be free and not subject to national appropriation. So international airspace, or it does not actually include outer space. The outer space is beyond international airspace. So from this we have learned about the certain important terms related to the international law of the sea. I hope you have I hope you have understood certain concepts and certain terms related to the international law of the sea. If you face any difficulty in understanding any of the content, please ask in the comment section. I will answer accordingly, and I hope to see you in the next lecture. Thank you all.